My son-in-law fed the pages into the shredder one by one, smiling the whole time. 40 years of work, a contract worth between $4 and $6 million, gone in under 3 minutes. My daughter stood next to him. Patricia, our attorney, watched from across the conference table without saying anything. What Derek didn't know was that he'd just shredded a copy. I sat there with my hands folded on the mahogany surface. The next morning, before 7, my old CEO was on the phone. The shredder was a Fellows industrial grade, the kind that sat in the corner of Patricia Morrison's office and hadn't been used in 3 years. I know that because Patricia told me afterward she'd had the machine serviced in January and it hadn't touched a single document since. Derek changed that on a Thursday afternoon in late October. He'd brought the pages himself, in a manila folder with my name written on the tab in his handwriting. Not mine. That detail stayed with me. Those pages were my original contract with Consolidated Peak Construction, 25 years of work, reduced to a document Derek had decided was no longer relevant. The contract established my consulting rights, my equity stake, and a revenue-sharing arrangement that James Chen and I had negotiated in a conference room in downtown Denver when Derek was still in college. It was worth, at current valuation, somewhere between $4 and $6 million, and beyond the lump sum, it carried a revenue-sharing clause tied to 15% of annual net profit for 5 years following any disputed separation. Derek had told Patricia it was worth nothing. He'd said that with the same pleasant confidence he used when he closed sales calls. Sarah stood beside him with her arms crossed. She'd done her hair differently that morning, pulled back. Severe. She looked like someone preparing for a performance rather than a family meeting. 3 years of marriage to Derek had changed the way she stood in rooms. I noticed that the way I noticed everything by then quietly, and without saying so out loud. Derek finished feeding the last page through and set the empty folder on the table. "That's the original," he said, looking at me. "Gone. Whatever claims you thought you had based on that document, they don't exist anymore." He smiled again. "We can move forward now." Patricia glanced at me across the table. I held her gaze for a moment, then looked back at Derek. I said nothing. I had learned, over 40 years in construction project management, that the men who talk the most in a room are usually the ones who've checked the fewest things. Derek had been a salesman for 11 months before he married my daughter. He was good at closing. He was less good at reading rooms. I unfolded my hands, picked up my coffee cup, and found it had gone cold. I drank it anyway. The next morning, James Chen called at 6:53. I was already at the kitchen table. The call lasted 11 minutes. James didn't waste the first one on pleasantries. He never had. Not in 25 years of working together. He asked me if I'd seen what Derek had brought to the meeting. I told him I had. He was quiet for a moment, the kind of quiet that meant he was choosing his next words carefully, which was unusual for James. He said, "Robert, that document he shredded, I have a copy. The original is still on file at the company. I pulled it this morning." I looked at the window above my kitchen sink. The light was coming in at a low angle, the way it does in Denver in late October, pale and flat across the counter. I had stood at that window for 31 years. My wife Ellen had stood at it before me. I told James to hold on to his copy. I told him not to say anything to anyone at the company yet. He said, "I figured you'd say that." Then he asked me how I was doing. I told him I was fine. He said he didn't believe me, but he'd let it go. That was the other thing about James. He knew when to let things go. What I didn't tell him was that I'd already called Patricia Morrison the previous evening. 40 minutes after Derek and Sarah had left her office, Patricia had watched the shredder run. She had not said a word during the meeting after that, and I had not expected her to, but on the phone that night, she told me she had noted the time and the circumstances in her file, and that she had a question about the language in the replacement document Derek had presented specifically, a clause in Section 4 that referenced a filing date she didn't recognize. She said she wanted to verify it before our next meeting. I told her to take her time. She said she wouldn't need much. Derek called 3 days later. It was a Thursday afternoon, and I was at my drafting table going through a set of elevation drawings I'd been asked to review for a former colleague, Old Habits, and the kind of work that keeps the hands useful. Derek's voice on the phone had the particular quality of a man who has rehearsed what he's going to say, but is trying to sound like he hasn't. He told me that in preparation for the transition of company records, he needed me to surrender all documents I still had in my possession that related to my former role. He used the word surrender. He said I no longer had standing to hold company materials, that my tenure had ended, and that retaining them could create complications. I let him finish. Then I asked him which documents, specifically, he was referring to. He said, all of them, Robert, contracts, correspondence, project files, anything from your time there. You don't have a right to those anymore. I wrote the word surrender on the notepad beside my drawings. Then I wrote the date and the time. I told him I'd look into it. He said he needed an answer by the end of the week. I told him I understood. After I hung up, I sat for a moment looking at the word I'd written. In 40 years of project management, I had signed contracts worth a combined figure that would take Derek 3 lifetimes to approach. I had managed crews of 200 men on sites where a single miscalculation could kill someone. I had been deposed 4 times, testified twice, and won both times. The idea that I didn't know what I had a right to hold was not something I needed to engage with directly, so I didn't. Instead, I called James again. This time, the conversation was longer. I asked him to tell me everything he remembered about the original employment contract, not the summary. The actual terms. James had been involved in drafting it. He remembered it the way engineers remember load-bearing specifications, not because they have to, but because those are the numbers that matter. He told me the contract contained a clause that was standard for senior project directors at the time, a provision that tied certain intellectual property rights and project attribution records to the individual, not the company, for a period of 15 years after the end of employment. He said that clause was in Section 7. He said it was still in effect. He also told me something I hadn't known. He said that 2 weeks earlier, someone at the company had requested the original contract be pulled from the archive. The request had gone through Derek's office. The archive manager, a man named Gary Tillman, who had worked in records for 18 years, had flagged it because the request hadn't come through the standard legal channel. Gary had made a copy before releasing the original and had noted the irregularity in his log. James said Gary had called him about it because Gary didn't know who else to call. I wrote Gary Tillman's name on the notepad. The following Tuesday, Gary Tillman called me himself. I don't know how he got my number, James. Probably or the old company directory that nobody had updated since 2019. His voice was careful, the voice of a man who has worked in records long enough to understand that the wrong phone call can cost him a job. He said, "Mr. Calloway, I don't know if James told you I'd be calling." I said James had mentioned his name. Gary said, "I want you to know the copy I made before I released the original from the archive. I still have it. And I still have the log entry. I noted the date, the request number, and the fact that it didn't come through the standard legal channel. It's all there." A pause. "I've been doing this job for 18 years. I know what a proper document request looks like. That wasn't one." I asked him if anyone at the company had followed up with him about it. He said, "Someone from Derek's office called last week, asked me to delete the log entry. Said it was a clerical error and I was creating unnecessary paperwork." Another pause, shorter this time. I told them I'd look into it. I said, "Did you delete it?" He said, "No, sir, I did not." I thanked him. He said he didn't need thanking, that he was just doing his job. I told him that was exactly right and that I hoped he'd keep doing it the same way. He said he intended to. Then he said, quietly, "Mr. Calloway, whatever's going on here, I think you should know that there are people in this building who remember what you built. That's all I wanted to say." He hung up before I could answer. I set the phone down on the notepad beside Gary's name. 18 years in records. A log entry nobody had deleted. A copy sitting in a filing cabinet that someone had already tried, once, to make disappear. It wasn't much, but it was one more thing Derek didn't know existed. James said, "Robert, what is he planning to do?" I told James what I had seen in Patricia's office. The shredder running, Derek's hand feeding the pages through one at a time, Sarah standing beside him. James was quiet again, longer this time. When he spoke, his voice had changed, not louder, but flatter, the way a man's voice gets when something he suspected has just been confirmed. He said, "That document was 40 years of your work. It had your signature on it from 1984. I said I was aware of that. He said, "I'm not going to pretend I understand what you're doing, but I'm going to trust that you're doing something." I told him I was. 3 days before the second meeting, Sarah called. Not about the meeting she called to ask if I wanted to come for dinner that Sunday. She said Derek was grilling. She said it the way she said things when she was trying to make something sound normal that wasn't. I told her I had plans. There was a pause, longer than it needed to be for a simple no. She said, "Dad, are you okay?" I told her I was fine. Another pause. Then, "Derek's been working late a lot. On the company stuff. I know it's been hard for you. The transition. I just want you to know I think he's trying to do right by everyone." I didn't answer immediately. I'd learned that Sarah filled silences the same way she had at 14, with the explanation she most needed to believe. She said, "He showed me some of the new filing structure. It looked really organized." I thought about the email Derek had sent James in January. I thought about Gary Tillman's log. I thought about the copy stamp in the corner of the document Derek had brought to Patricia's office. 4 millimeters high, pale gray, easy to miss unless you were looking. Sarah had been standing in that room. She had been standing right next to him. I said, "I'm sure it is." She said, "Okay, well, the offer stands." After we hung up, I sat at the drafting table for a while. She had not asked about the meeting. She had not asked about the shredder or the copy stamp or why Patricia had gone quiet when she looked at the document's corner. She had been in that room. She had seen Patricia's face. And she had chosen, instead, to call me about dinner. I didn't fault her for it. She was 34 years old, and she had built 3 years of her life inside a set of assumptions that were about to be tested in a courtroom. The mind does what it can with what it has. I knew that. I had watched my own mind do the same thing for months before I stopped letting it. The morning of the second meeting at Patricia's office, Derek arrived 12 minutes early. I know because Patricia's assistant, a young woman named Cora, who had been with the firm for 2 years, mentioned it when I came in. She said he'd been standing at the reception desk asking questions about the filing process. I thanked her and went to the conference room. Derek had a folder in front of him, thicker than the last one. He had his attorney with him this time, a man named Hollis I'd never met, who wore a suit that cost more than my first car and had the manner of someone accustomed to being the smartest person in rooms he hadn't earned the right to enter. Sarah sat beside Derek. She didn't look at me when I came in. Derek waited until Patricia had settled into her chair. Then he opened the folder and slid a document across the table. He said, "I want to address the original contract from Robert's tenure. It's no longer valid. The company has superseded it through a series of operational updates, and we're here to formalize its removal from any active consideration." He said the words "no longer valid" the way a man says them when he's practiced them enough that he believes they're true. Patricia picked up the document. She read the first page without expression, then she turned to the second. Her pen was in her hand, but she wasn't writing anything. She was reading the way lawyers read when something doesn't match what they expected, slowly, and twice. I folded my hands on the table and waited. Outside the window, a truck was backing into the loading dock of the building across the street, its beeper going at steady intervals. I counted 7 before Patricia set the document down and looked at Derek over the rim of her glasses. She said, "Mr. Calloway, what filing date is referenced in Section 4 of this document?" Derek looked at Hollis. Hollis leaned forward and said the date. Patricia wrote it down. She said, "I'll need to verify that against our records." She said it the way someone says something they've already verified. Derek smiled and said that wouldn't be a problem. He said everything was in order. I picked up my coffee cup. It was warm this time. I drank it and said nothing. He fed the first page into the shredder himself. Not a paralegal. Not Hollis. Derek stood up from his chair, walked to the corner of Patricia's office, where the shredder sat on a low credenza beside the filing cabinet, and fed the first page in by hand. The machine was a cross-cut model, the kind that leaves confetti, not strips. It took the page in 4 seconds. He walked back and picked up the second page. Patricia Morrison had been a family law attorney for 27 years. She had an office on the 9th floor of a building on 17th Street, and the walls held 3 diplomas and 1 framed photograph of her standing outside a courthouse in what looked like winter. She had processed my wife Ellen's estate documents 8 years ago, and she had handled the initial partnership paperwork when I brought Derek into the company as a junior sales associate 3 years after that. She was not a woman who startled easily, but when Derek picked up the second page, she put her hand out, flat on the table, palm down. She said, "Mr. Calloway, before you continue, can you confirm whether this is the original or a copy?" Derek said it was the original. He said it without looking at her. Patricia reached across the table and took the remaining pages from his hand. She did it slowly and without asking twice. Derek let her take them, I think, because Hollis was watching, and Derek had spent 3 years learning that the appearance of cooperation was its own kind of leverage. She set the pages on the table and turned to the last one first. Then she turned to the cover page. She looked at the bottom right corner for a long moment. She set the document down. She said, "This is a copy." Derek said that was impossible. Patricia turned the cover page toward him and pointed to the corner without touching it. There was a small stamp there, the kind that comes from a photocopier's document feeder, pale gray, easy to miss unless you were looking. It said "Copped" in letters about 4 millimeters high. Derek looked at Hollis. Hollis looked at the stamp. The truck outside had stopped beeping. The only sound in the room was the cross-cut shredder's cooling fan, still running after the 1 page it had taken. Patricia looked at me. I had not moved in my chair. I set my coffee cup down on the coaster she had put out at the start of the meeting, and I said, "I sent the original to James Chen 3 months ago, for safekeeping." The room did not react all at once. It changed the way a room changes when the temperature drops gradually. Then, noticeably, Hollis's pen stopped moving. Sarah, who had been sitting to my left with her hands folded in her lap, lifted her chin and looked at me. I did not look back at her yet. I was watching Patricia. Patricia wrote something on her notepad. She wrote it carefully, the way she wrote everything, with the deliberate pressure of someone who understood that written records outlast conversations. She said, "When you say you sent it to Mr. Chen, this would be James Chen, formerly of Rockwell Pacific Construction." I said yes. I told her it had been the 3rd week of August. I had driven it to his house in Cherry Hills myself because I did not want it going through a courier service or a mailroom. James had signed a receipt for it, which he kept and which I photographed before I left his driveway. Patricia said, "And Mr. Chen is aware that this document may be relevant to current proceedings." I said he was. She looked at Derek then, not at Hollis, not at her notepad, at Derek. She said, "Mr. Calloway, you've just attempted to destroy a copy. The original is currently in the possession of a third party, properly receipted, and, to the best of my knowledge, legally binding under the terms of the original agreement." She paused. "Do you understand what that means?" Derek said the document was outdated. He said it had been superseded by subsequent agreements. His voice had changed not dramatically, not the way voices change in films, but in the way a voice changes when the person using it is no longer certain of the ground beneath them. Hollis put his hand on Derek's arm. Derek did not seem to notice. Patricia said, "That's a question for the court to determine. What I can tell you is that the document you brought to this meeting is not the original, and the original has not been destroyed." Sarah made a sound, not a word, just a small, involuntary intake of breath. I looked at her then. She was looking at Derek. Her hands, which had been folded neatly in her lap since the meeting began, were no longer folded. One was pressed flat against the table. She was looking at her husband the way you look at something you thought you recognized but are no longer sure of. Derek said that James Chen had no standing in this matter. He said it quickly, and the quickness was a tell. 3 years of watching Derek work a room had taught me that he spoke slowly when he was confident and quickly when he was filling space. Patricia said, "Mr. Chen's standing isn't the issue at the moment. Custody of the original document is—" She took off her glasses and set them on the table. "I'd recommend we pause this meeting until I've had a chance to contact Mr. Chen's office and confirm the document's current status." Hollis said that a pause wasn't in his client's interest given the timeline. Patricia said, "With respect, Mr. Hollis, your client just attempted to feed what he believed to be an original contract into a shredder during a formal legal proceeding. A pause is very much in everyone's interest." The shredder's cooling fan clicked off. The room was quiet. Derek looked at me for the first time since he'd walked to the credenza. He had the same expression he'd worn at the Millbrook Roadhouse 18 months ago, when I had told him quietly that the property was in a trust and could not be transferred without the trustee's consent, and he had not known there was a trustee. That expression lasted about 4 seconds before he replaced it with something more composed. He was good at replacing expressions. He had been doing it for years. But Sarah had seen it. She was still looking at him. Her face had the particular stillness of someone who is not yet ready to say what they are thinking, but who has already thought it. I folded my hands on the table. Patricia was already writing again, longer notes this time, with dates and names. Outside the window, the loading dock was quiet. The afternoon had gone flat and gray, the way Denver afternoons go in late October when the light runs out before the day does. 40 years in construction had taught me one reliable truth about foundations. The crack you can see is never the only one. You find the visible crack, you follow it down, and 3 times out of 4, there's a second one running perpendicular, invisible from the surface, carrying more load than the first. Derek had spent 3 months trying to locate the document he believed was the foundation of my position. He had found what he thought was it. He had walked it into a room with 2 attorneys and a shredder, and he had fed 1 page into the machine before Patricia stopped him. He had been working from a copy the entire time. The original was 40 minutes south of this office, in a fireproof cabinet in James Chen's study, next to a signed receipt with my signature and James's and the date written in James's handwriting, August 19th, a Tuesday, at 4:15 in the afternoon. Patricia looked up from her notes and said she would be in touch with both parties by end of week. She said it to the room, not to either side specifically. That was her way of saying the meeting was finished. Derek stood. Hollis stood. Derek straightened his jacket and said, in the pleasant voice he used when he was performing composure, that he looked forward to Patricia's follow-up. Patricia said she was sure he did. Sarah did not stand immediately. She stayed in her chair for a moment after the men had moved toward the door, her hand still flat on the table, her eyes somewhere in the middle distance between the window and the wall. When she finally stood, she looked at me once, not a long look, just a second, and then she followed her husband out. I stayed seated while Patricia gathered her notes. She did not ask me anything else. She did not need to. After a moment, she said, quietly, without looking up from the page, "You've known about the copy for some time." I said I had suspected it for about 6 weeks. I said I had not been certain until today. She said, "The original is still legally binding." I said I knew. She capped her pen and set it parallel to the notepad, the way she always did at the end of a meeting. Outside, a car horn sounded once from 17th Street and then was gone. I picked up my jacket from the back of the chair. The coffee cup was empty. I left it on the coaster and walked to the door. The call came at 6:47 the next morning. I was already awake, sitting at the kitchen table with the Denver Post open to the business section, a habit from 30 years of project schedules that started before sunrise. The phone showed James Chen's name. I let it ring once more before I answered. James and I had worked together for 25 years. He had been the one who brought me on as project director when the company was still operating out of a 2-room office on Larimer Street, before the Colfax expansion, before the government contracts. He was not a man who called before 7 unless the matter was specific. He said, "I got an email from a Patricia Morrison last night, your attorney." I said yes. She asked me to confirm the status of your original employment contract, the one from 1997. Outside the kitchen window, the Rockies were just beginning to catch the early light, that particular pale orange that sits on the peaks for about 20 minutes before the sky goes full blue. I had watched that light from this window for 19 years. My wife used to say it looked like the mountains were deciding whether to wake up. I told James I was listening. He was quiet for a moment, not the quiet of a man choosing words, but the quiet of a man who has already chosen them and is making sure the line is clear. Then he said, "Robert, I need to tell you something I should have told you 3 months ago." The coffee was still hot. I set the mug down and did not pick it up again. He told me that in late January, he had received an email from Derek. The email was brief, 3 sentences. Derek wrote that the original 1997 contract was no longer operationally relevant, that a revised agreement had superseded it, and that James should destroy any physical copies in his possession to avoid confusion during the ongoing transition. He used the phrase, "avoid confusion," twice. James had read the email on a Tuesday morning and had not replied to it. He had printed it, put it in a manila folder, and placed that folder in the filing cabinet in his home office, behind the property tax records for his house in Cherry Hills. I asked him why he had not replied. He said, "Because I've known you for 25 years, and because the contract he was asking me to destroy had your signature and mine on the same page. I wasn't going to touch it based on an email from a sales associate." He said the words "sales associate" the way an engineer says them, not with contempt exactly, but with precision. Derek had been a sales associate for 4 years. He had never managed a project. He had never pulled a permit, never read a soil report, never stood on a job site at 5 in the morning when the concrete pour was running behind and the inspector was already in the parking lot. I asked James if he still had the original. He said, "It's in the same cabinet. I can see the folder from where I'm sitting." I looked at the mountains. The orange was already fading. James said, "Patricia's email mentioned a clause. She asked me specifically about Section 14, subsection C." Section 14, subsection C. I had not read that contract in 11 years, but I remembered the afternoon it was drafted, Thursday in October, in a conference room on the 8th floor of the old Wells Fargo building, with James and the company's outside counsel at the time, a man named Howard Briggs, who wore the same brown blazer to every meeting. The clause had been Howard's suggestion. He said it was standard in senior executive agreements of that duration, that it protected both parties in the event of a disputed separation. I had signed the contract and filed my copy and not thought about that clause again until Patricia mentioned it the previous evening in a low voice, after Derek and Sarah had left the room. James read it to me from memory. He had a contractor's memory, the kind that retains load specifications and zoning setbacks, and the exact language of agreements that determine who owes what to whom. The clause stated that in the event Robert Calloway was removed from his position through means determined to be without cause or in bad faith, he was entitled to compensation equal to 15% of the company's net profit, calculated annually for a period of 5 years from the date of removal. 15%, 5 years. The company had posted its strongest revenue in a decade last year. I knew that number. I had watched the quarterly reports for 3 years, the way you watch a thing you built from the outside, through glass. Derek had been in that room yesterday. He had fed the original pages through the shredder with the particular satisfaction of a man who believes he is solving a problem permanently. He had not known about Section 14, subsection C, or he had known, and that was exactly why he was in that room with a shredder. Either answer told the same story. James said, "He asked me to destroy the document that would have entitled you to that clause." I said I understood. And now there's an email with his name on it, time-stamped, asking me to do exactly that. The kitchen was very quiet. A truck passed on the street outside one of the early delivery routes, the sound of it rising and fading in about 4 seconds. I asked James if he would be willing to send Patricia a copy of the email and a signed statement confirming the original contract was intact and in his possession. He said, "I've already drafted the statement. I was waiting for you to ask." That was James. He had always been 2 steps ahead of the paperwork. It was why the company had survived the 2008 contraction when 3 of its competitors had not. He did not wait for problems to arrive fully formed. He prepared for them before they had names. He asked me one more question before we ended the call. He said, "Robert, do you want me to send the email to Patricia directly, or do you want to be on the copy?" I said to send it to Patricia directly and to copy me. He said he would do it within the hour. I thanked him. He said there was nothing to thank him for, that he was doing what any reasonable person would do when asked to destroy a legal document by someone who had no authority to make that request. He said it evenly, without drama. Then he said, "I'll see you on the other side of this," and ended the call. The coffee had gone cold while we were talking. I drank it anyway. There is a particular clarity that comes from a cold cup of coffee at 6:50 in the morning when you understand, for the first time with complete certainty, the exact shape of what is coming. Not the outline of it, the shape. Every edge. Derek had walked into Patricia's office the previous afternoon believing he was closing a door. He had shredded what he believed was the last obstacle. He had looked at me across that table and seen a man who had already lost. A man whose 40 years of work could be fed through a machine in under 3 minutes. He had smiled when the shredder finished. I had watched him smile. What he had actually done, in that room, with Patricia Morrison watching and the sound of the motor running, was produce the most precise evidence of intent I could have asked for. He had destroyed a copy. The original was in a filing cabinet in Cherry Hills, behind the property tax records, exactly where James had put it the day Derek's email arrived. And now there was a time-stamped email, written in Derek's own words, asking a witness to destroy it. He had not built a case against me. He had built one against himself. I folded the newspaper and set it on the table. The business section faced up. I left it there and went to get my jacket. Patricia would have the email before 8. The statement would follow. There were 3 more things that needed to happen before the next meeting, and I knew the order of them. The mountains were fully lit now. The orange was gone. The sky was the flat, certain blue that means the day has started and there is no going back to what it looked like before. 2 days after the meeting in Patricia's office, Sarah called and asked if I would come to the house. She did not say why. She said Derek wanted to talk. She said it the way she used to say things when she was 12 and had broken something and needed me to come see the damage before she explained it, that particular flatness in her voice that meant she already knew what was coming and had decided not to fight it. I told her I would be there at 7. The house was a 4-bedroom colonial in Cherry Creek that Derek had insisted they buy 3 years ago, when the market was high and the mortgage rate was higher. I had helped with the down payment, $240,000. Wired from the account my wife Margaret and I had kept since 1991. Derek had thanked me once, at dinner, and not again. I parked on the street. The porch light was on. Sarah opened the door before I reached the steps, which meant she had been watching for me, which meant she was nervous, which meant she had some idea of what was about to happen. Derek was in the living room, standing near the fireplace. He had his arms crossed. He was wearing the kind of casual clothes men wear when they want to look relaxed but have rehearsed what they are about to say. A glass of water sat on the mantel beside him, untouched. Sarah sat on the couch. She did not look at me when I came in. I sat in the chair across from Derek. He waited until I was settled, which was a technique make the other person comfortable, then take that comfort away. I had used it myself, in project reviews. When a subcontractor had submitted numbers that didn't hold, I recognized it for what it was. "Robert," Derek said, "I think it's time we were honest with each other." He explained, in the organized way of someone who has written and rewritten a speech, that the company needed to move forward, that the contracts from the previous era, his phrase, previous era, were holding back growth, that the board had been patient, but patience had limits, that he had spoken with the investors, and they agreed the project director role needed to be filled by someone who understood the current market. "You're a burden to the company," he said. "Your time is over. I'll be appointing a new project director, someone younger, more dynamic, someone who can actually move things forward." Sarah was looking at the carpet. Her hands were folded in her lap, and she was pressing her thumbs together the way she did when she was trying not to say something. I watched her for a moment. She did not look up. I looked back at Derek. The glass of water on the mantel had a small ring of condensation forming beneath it, darkening the wood. He did not notice it. I thought about the conference table in my first office at Meridian Construction's solid oak, 30 years old, the kind of surface that showed every ring, every scratch, every meeting that had ever happened on it. Derek's mantle was composite. It would stain and not recover. "I understand," I said. Derek's jaw moved slightly. He had expected something else, a protest, an argument, a display of the hurt he believed I was feeling. The absence of it shifted something in the room. He recalibrated. "I want to be clear," he said. "This isn't personal. It's a business decision. You had a good run. 40 years is something to be proud of." He said 40 years, the way a man says a number he has looked up but does not actually understand. I stood up. Derek said, "Robert, sit down. We're not finished." I picked up my jacket from the arm of the chair. I looked at him once, not long, just long enough. I said, "You should have asked James to delete the email, not the document." Derek's face did something he couldn't control. It lasted less than 2 seconds. Then he put the composed version back in place, but the composed version was a different shape than it had been a moment before, and we both knew it. Sarah looked up then. Her eyes met mine for a moment, just a moment, and in them I saw the thing she had been pressing her thumbs together to keep down. She knew this was wrong. She had known it the whole time. That was the part that would take the longest to sort through. Later, when there was time for it. I picked up my jacket from the arm of the chair. "Robert!" Derek's voice had a different quality now. Harder. The rehearsed version was finished, and what came after it was the real thing. "If you try to take this to court, I will prove that you've been hiding company assets. I've got documentation. You'll lose, and you'll lose in front of people who've known you for 30 years. I stopped at the doorway. The front hall was dark. Sarah had not turned the hall light on when I came in, and neither had I. Derek was still talking something about filings, something about a timeline he had already set in motion. His voice had the particular energy of a man who believes that saying a thing loudly enough makes it true. I did not turn around. There are moments when silence is the only honest response, not because there is nothing to say, but because everything worth saying is already in motion, already documented, already waiting in a time-stamped email that a lawyer named Patricia Morrison had received before 8 o'clock that morning. Derek's threats required an audience that didn't know what I knew. I was not that audience. I walked to my truck and sat for a moment before starting the engine. The Cherry Creek neighborhood was quiet at this hour. A neighbor 2 houses down was walking a dog, moving slowly under the streetlights. The dog stopped to investigate something in the grass, and the man waited without pulling the leash. That kind of patience, the kind that costs nothing because you're not afraid of what comes next. My phone buzzed once on the seat beside me. A text from James Chen, sent at 7:41 p.m., email delivered to your attorney. Statement attached, ready when you are. 3 words at the end. The way James always finished things that mattered, ready when you are. I set the phone face down on the seat and started the engine. The drive back to my house in Washington Park was 22 minutes on a quiet night. I had 3 things left to arrange before the next hearing, and I knew the order of all of them. Derek had called me a burden. He had said my time was over. He had threatened to prove things that he did not. In fact, have the documentation to prove, because the documentation that existed told a different story, and it was already in Patricia's hands, and it had been put there by the man who wrote it. The streetlights on Colorado Boulevard came on as I drove south, one by one in sequence, the way things do when they are finally ready. The courthouse on Bannock Street had been there since 1933. I had been in it twice before, once in 1991 on a contract dispute with a subcontractor in Pueblo, and once in 2003 when a material supplier tried to renegotiate terms after delivery. Both times I had walked out with what I came for. The building smelled the same way it always had: old paper, floor wax, and the particular stillness of rooms where decisions get made and then written down. Patricia met me in the corridor outside courtroom 7 at 8:45. She was carrying 2 accordion folders and a leather briefcase, and she had the look of someone who had been awake since 5. She handed me a copy of the amended filing and said, "He retained outside counsel, a firm from Cherry Creek. They filed a motion to dismiss yesterday afternoon." I said, "What grounds?" She said, "They're arguing the original contract was superseded by the restructuring agreement from 3 years ago." I asked her if it was. She said, "No, and I have 17 pages explaining exactly why not." She looked at the accordion folders, plus what James sent over. We went in and sat at the plaintiff's table. The room had 12 rows of gallery seating, dark wood benches worn smooth at the edges. Derek was already at the defense table with a man I didn't know, late 30s. Good suit, the kind of careful posture that comes from billing $400 an hour and knowing it. Derek was in a charcoal jacket I had seen before at a company dinner 2 Christmases ago. He had worn it the night he told the assembled staff that the company was entering a new chapter. He had not mentioned my name once in that speech. I had sat at the end of the table and watched him hold a glass of wine and talk about the future as though the past were something that had simply dissolved. He looked at me when I came in. Then he looked away. Sarah was in the 3rd row of the gallery, on the left side, by herself. She had her hands in her lap and her coat folded over the seat next to her. We had spoken twice in the past 3 weeks, both times briefly, both times about logistics rather than anything else. She looked like she hadn't slept well. I didn't look at her for long. There would be time for that later, or there wouldn't. And either way, this morning had its own business to attend to. Judge David Hartley came in at 9:02. He was 61 years old, had been on the bench for 14 years, and had the particular economy of movement that comes from presiding over rooms where other people do most of the talking. He sat, reviewed the docket, and looked up at both tables. "Yeah, we're here on the matter of Morrison filing on behalf of Robert Calloway regarding enforcement of an original employment compensation contract dated March 1983 and the question of whether subsequent corporate restructuring documents superseded that contract." He set the papers down. "Counsel for the defense has filed a motion to dismiss. I've reviewed it. I'm going to hear argument before ruling. Ms. Morrison, you'll have time to respond. Let's proceed." Derek's attorney, his name was Gareth Sloan. I learned from the filing, stood first. He was good. He laid out the restructuring argument clearly, cited 3 Colorado precedents, and spoke for 11 minutes without looking at his notes more than twice. The argument was that the 2021 restructuring agreement, signed by all current stakeholders, had effectively replaced the legacy compensation framework, including any provisions from contracts predating the corporate reorganization. He said the words legacy framework 4 times. He said predating the reorganization 3 times. He was building a wall, 1 brick at a time, and he was building it well. I kept my hands folded on the table. Patricia made 2 notes on her legal pad. When Sloan finished, Judge Hartley looked at Patricia. "Ms. Morrison." She stood. She did not use notes for the first 4 minutes. She explained, without hurry, that the restructuring agreement from 2021 contained a specific carve-out clause, Section 11, subsection C, that explicitly preserved all pre-existing individual compensation agreements entered into before January 1, 2000. She said the clause had been drafted by the company's own corporate counsel and signed by the then CEO. She said the then CEO was available to testify to its intent. Sloan objected that the carve-out was ambiguous. Patricia said it was not ambiguous. She said it was. In fact, the least ambiguous paragraph in the entire 37-page restructuring document, and she handed the court clerk 3 copies of the document with Section 11, subsection C, highlighted in yellow. Judge Hartley read it. He read it again. He said, "Motion to dismiss is denied. We'll proceed to the substance of the claim." He looked at Sloan. "Counsel, your client will testify." Derek was sworn in at 9:44. Sloan walked him through the prepared questions first, the standard architecture of direct examination. Derek spoke about his role at the company, the restructuring process, his understanding of the compensation framework. His voice was even. He had rehearsed this. I could tell by the way he paused in the same places each time, the way a person pauses when they have practiced pausing rather than when they are actually thinking. Then Patricia stood for cross-examination. She began at the edges. She asked Derek about his tenure at the company when he had joined, what his initial role had been, who had briefed him on company structure during onboarding. He answered each question with the same measured tone. Then she asked him about the meeting in Patricia's own office 3 weeks prior, the one at which a document had been fed into a shredder. Sloan objected relevance. Judge Hartley said, "I'll allow it. Answer the question. Mr. Calloway." Derek said, "There was a meeting." "Yes." Patricia said, "And at that meeting, a document was shredded." Derek said, "Some papers were disposed of." "Yes." Patricia said, "What papers?" Derek said, "I don't recall the specific." Patricia said, "Mr. Calloway, are you aware that the deliberate destruction of documents relevant to pending or reasonably anticipated litigation constitutes spoliation of evidence, and that in Colorado it carries both civil and criminal exposure?" The room was quiet for a moment, not the quiet of people waiting, the quiet of people paying attention. Derek said, I didn't intend to destroy anything relevant to." Judge Hartley took off his reading glasses and looked at Derek. He said, "Mr. Calloway, I wanted to ask you a direct question, and I'd like a direct answer. Were you aware, at the time those documents were shredded, that litigation concerning those documents was either pending or reasonably anticipated?" Derek looked at Sloan. Sloan gave him nothing. Derek said, "I know." Judge Hartley said, "You were not aware." Derek said, "I didn't think." Judge Hartley said, "Ms. Morrison." Patricia reached into the first accordion folder and removed a printed email. She handed copies to the clerk, to Sloan, and to the judge. She said, "Your Honor, I am entering into evidence Plaintiff's Exhibit 14, an email sent from the defendant's corporate account on October 3rd of this year, addressed to James Chen, former CEO of Callaway Meridian Construction." I had read the email once, the evening James forwarded it to Patricia. I did not need to read it again. I knew what it said. Patricia read it aloud. The email was 6 sentences. In the 3rd sentence, Derek had written, "The original contract document needs to be destroyed before this goes any further. Can you handle that from your end, or do I need to come in person?" The 5th sentence read, "If the original is gone, there's nothing to enforce." Patricia set the printed copy down on the podium. She said, "Your Honor, the defendant sent this email 4 days before the shredding occurred in my office." Judge Hartley was looking at Derek over the rim of his glasses. He said, "Mr. Calloway, you told this court, under oath, that you were not aware that the documents were relevant to anticipated litigation." Derek said nothing. Judge Hartley said, "This email sent from your account refers explicitly to destroying the original contract to prevent enforcement. That is a direct statement of intent." He set the email down. "This is not ambiguous. This is evidence of deliberate, premeditated destruction of a legal document for the purpose of obstructing a legal claim." He looked at Sloan. "Counsel, your client has a significant problem." Sloan leaned over and spoke quietly to Derek. Derek's face had gone through several things in the past 2 minutes. The careful evenness was gone. What was underneath it was not anger. It was the specific blankness of a man who has just understood that the room he thought he was standing in has different walls than he believed. Patricia continued. She placed the original contract on the evidence table, the physical document, in a clear archival sleeve, the one James Chen had kept in his personal files for 41 years, the one he had driven down from Fort Collins himself and handed to Patricia in her office on a Tuesday morning. 41 years of paper. The edges had yellowed slightly. My signature was on the last page, and James's signature was below it, and the date read March 14th, 1983. Patricia said, "Your Honor, this is the original compensation agreement between Robert Calloway and Callaway Meridian Construction, executed in 1983. It has been authenticated by the signatory former CEO James Chen, who is present today and available to testify. The document establishes a 15% net profit participation right, vesting after 10 years of continuous service, in perpetuity, unless terminated by mutual written agreement of both parties. Sloan said there had been no such clause disclosed during the restructuring. Patricia said the carve-out in Section 11 meant it didn't need to be separately disclosed. It was preserved by operation of the restructuring agreement itself. She said this was the precise reason the carve-out existed, to protect exactly these kinds of legacy arrangements. Judge Hartley reviewed the original document. He reviewed the restructuring agreement. He asked Patricia 3 questions about the authentication chain. She answered all 3 without hesitation. Then he looked at Derek. He said, "Mr. Calloway, I want to ask you about this 15% provision specifically. Were you aware of this compensation arrangement when you joined the company?" Derek said, "No." Patricia said, "Your Honor, I'd like to enter Plaintiff's Exhibit 15. It was a company-wide onboarding email from James Chen, dated September 8th, 2 years ago, the month Derek had joined Callaway Meridian as a sales associate. The email was addressed to all new employees and included, as an attachment, a summary document titled Company History and Legacy Agreements for New Staff Reference. The summary document contained a full paragraph describing the 1983 compensation arrangement with the founding project director, including the 15% net profit participation clause and its perpetual nature. Patricia said, "The defendant received this email. His name is on the distribution list. The attachment was opened. The server logs confirm it was accessed from his workstation on September 10th of the same year." The room was very still. Derek looked at his attorney. Sloan had stopped taking notes. Judge Hartley said, "So to summarize what this court has established, the defendant was aware of the 15% compensation provision at the time he joined the company. He sent an email explicitly requesting the destruction of the original contract document. He participated in the shredding of documents in a legal office 4 days after sending that email. And he testified under oath this morning that he was unaware of the document's relevance to anticipated litigation." He paused. He set his pen down. "Mr. Calloway, I'm going to give you one opportunity to speak to this court about any of these points before I proceed." Derek said, and stopped. He said, "I thought the restructuring had—" He stopped again. Sloan said, "Your Honor, I'd like to request a brief recess to confer with my client." Judge Hartley said, "You'll have 5 minutes." They conferred at the defense table in low voices. I did not watch them. I looked at the original contract in its archival sleeve on the evidence table. 41 years. March 14th, 1983. I had been 31 years old. James had been 38. The office where we signed it had a window that looked out over the South Platte, and there had been snow on the ground, and James had made a joke about the coffee being cold, and I had said something about the coffee always being cold in March, and we had both laughed, and then we had signed our names. The recess ended. Sloan stood and said his client would not be offering additional testimony on the points raised. Judge Hartley nodded. He said, "Then I'll proceed to ruling." He spoke for 7 minutes. He was precise and unhurried. He ruled that the original 1983 compensation agreement was valid and enforceable, that the 2021 restructuring had not superseded it by operation of the explicit carve-out clause, and that Robert Calloway retained full rights to the 15% net profit participation as specified. He calculated the outstanding obligation at approximately $1.2 million based on audited net profit figures for the preceding 5 years, payable within 90 days. With interest accruing thereafter. He ordered the company to provide annual profit statements to Patricia's office for the purpose of calculating ongoing payments. Then he addressed the destruction of legal documents. He said the evidence before the court established a clear pattern of deliberate, premeditated spoliation. He referred the matter to the district attorney's office for criminal review. He said that based on the email evidence and the sworn testimony, he was issuing an immediate order barring Derek Calloway from holding any management, executive, or signatory authority within Callaway Meridian Construction or any successor entity for a period of 10 years. He said that order was effective immediately. Derek's attorney began to speak. Judge Hartley said, "The order stands. Counsel, if you'd like to appeal, you know the process." Two officers from the courthouse security detail were already at the side door. One of them walked to the defense table and said something to Derek in a low voice. Derek stood. He was still wearing the charcoal jacket. He looked across the room, not at Patricia, not at the judge, not at the evidence table with the original contract in its sleeve. He looked at me. He said, "Dad." I did not answer. He said, "I didn't think it would." I looked at him the way you look at a structural report that has confirmed what you already knew. You read it. You note it. You file it. I had nothing to say to him that the documents had not already said more clearly. The officer touched his elbow and Derek turned away. They walked him toward the side door. His footsteps were the only sound in the room for those few seconds. I heard Sarah in the third row. Not words, just a sound, quiet and sharp, the kind of sound a person makes when something they have been holding finally gives way. I did not turn around immediately. I let the room settle. Then I turned. She was still in her seat. She had not moved toward the door where Derek had gone. Her coat was still folded on the seat beside her, and her hands were in her lap, and she was looking at me with the expression of someone who has just finished reading a letter they should have read years ago. Her eyes were wet. She did not look away. I held her gaze for a moment. Then I nodded. Once. The way you nod when something has been understood and does not need to be said aloud. Patricia touched my arm. She said, "I need to get the original filed with the clerk before noon." I said, "Go ahead." She picked up the accordion folders and the archival sleeve and walked to the clerk's window at the front of the room. The clerk, a woman named Donna, who had been in that courtroom for, I later learned, 9 years, took the documents and began processing them with the particular efficiency of someone who has seen every variety of outcome and treats each one with the same careful attention. I sat for another minute. The gallery had mostly cleared. The defense table was empty. Judge Hartley had gone back through the door behind the bench. The room had the quality of a space that has done its work and is now simply waiting to do it again for someone else. 41 years was a long time to carry a piece of paper. James had carried it in a file cabinet in his home office in Fort Collins, behind a folder labeled Callaway Personal, and he had kept it there through 3 moves and 2 office renovations and the death of his own wife and the sale of the company and everything else that had happened in 4 decades. He had kept it because he believed it meant something, because he was the kind of man who understood that a signature is a record of what 2 people agreed was true, and that truth does not expire because someone finds it inconvenient. Derek had fed the pages of a copy into a shredder one by one. He had done it in front of a lawyer and in front of my daughter and in front of me. And he had smiled while he did it because he believed that destroying the copy destroyed the fact. He had been wrong about that. He had been wrong about several things, and the court had now documented each of them in the public record, in a building that had been standing since 1933, in a room that smelled like old paper and floor wax and the particular stillness of decisions being made and written down. I picked up my copy of the ruling from the table, folded it along its crease, and put it in my jacket pocket. Then I stood, buttoned my jacket, and walked toward the back of the room. Sarah was still in the 3rd row. As I passed her, I stopped. She said, "Dad," just that. I said, "I know." She said, I didn't know about the email. I didn't know he'd." I said, "I know that too." She looked down at her hands. Then she said, "What do we do now?" I thought about the drive back to Washington Park. I thought about the streetlights on Colorado Boulevard coming on one by one, in sequence, the way things do when they are finally ready. I thought about March 14th, 1983, and a window over the South Platte, and snow on the ground, and cold coffee, and a joke about March, and 2 signatures on a piece of paper that had just been read aloud in a courtroom and entered into the public record. I said, "We'll talk. Not today." She nodded. I walked to the back of the courtroom and pushed through the door into the corridor. Patricia was at the clerk's window, still processing. I caught her eye, and she raised one finger 1 more minute. I nodded and walked to the window at the end of the corridor. It looked out over Bannock Street. The morning was clear and cold, the kind of Denver cold that has no ambiguity in it, just air and light and the fact of the season. My phone was in my pocket. I did not take it out. There was no call to make. Everything that needed to happen had happened, in the right order, in the right room, in front of the right people. The document was filed. The ruling was entered. The original contract, 41 years old, edges slightly yellowed, 2 signatures on the last page, was now part of the permanent court record. Patricia came down the corridor with her folders. She said, "It's filed. Donna said certified copies will be ready by Thursday." I said, "Thank you." She said, "Robert," she paused, "you've been patient with this for a very long time." I said, "The contract was patient. I just kept it company." She smiled at that, briefly. Then we walked toward the elevator, and the doors opened, and we went down. The judgment had been entered on a Thursday. The certified copies were ready by the following Monday. Donna at the clerk's office called me herself to let me know, which she didn't have to do. Patricia picked them up. I drove home on 6th Avenue the same way I'd driven it for 30 years, past the concrete supply yard on the left and the old Hennessy building on the right, the one my crew had retrofitted back in 1998. The scaffolding was different now. Everything else was the same. Derek had 30 days to comply with the financial terms of the judgment. His attorney, a man named Curtis Briggs, who had spent most of the hearing looking at his phone under the table, filed 2 motions for extension. Judge Harlan denied both. On the 28th day, Derek liquidated his shares. The number was $280,000, not a round figure, $280,000 even, because that was what the appraisal said the shares were worth at the time of the judgment, and the court had accepted that number without modification. Patricia called me when the transfer cleared. She said, "It's done." I was standing in my kitchen, looking at the window above the sink. Outside, a crow was sitting on the fence post. I said, "Thank you, Patricia." She said, "Get some rest." I told her I would. James Chen made the announcement at the company's quarterly review in February. I wasn't in the room for it. I had asked him not to include me in the formal presentation, and he understood why. What I knew was this: he stood up in front of the management team, the senior project leads, and 2 board members who had flown in from Phoenix, and he said that effective the 1st of March, the company would be bringing on a strategic advisor in the area of project development and contract oversight. He said the position would carry a salary of $120,000 a year. He said the advisor would have advance notice of all major management decisions and direct access to the board. Marcus Tilden, the regional sales director who had hired Derek 3 years earlier, asked who the advisor would be. James said my name, according to Linda Reyes, who had been the office manager for 19 years and called me that afternoon. The room was quiet for a moment. Then Marcus said, "Good." That was all he said. Linda told me his voice was steady when he said it. Sarah filed for divorce 6 weeks after the judgment. I didn't know until she called me on a Sunday evening. And even then, she didn't say it directly at first. She said she needed to talk. I told her to come over. She sat at my kitchen table for 2 hours, and most of that time she spent looking at her hands. She said she hadn't known about the contract. I told her I believed her. She said she hadn't known about the other accounts either, the ones Derek had opened under a subsidiary structure, the ones her own attorney had found during the asset discovery process. She said, "He hid things from me, too. Dad." Her voice didn't break when she said it. She was 34 years old, sitting in the same chair she had sat in as a child, and she looked like someone who had stopped being surprised and started being clear-eyed instead. The asset division took 4 months because Derek had concealed funds. Sarah's attorney successfully argued for a larger share of what remained. What remained wasn't much. Derek's liquid assets. After the judgment transfer and the legal fees and the penalties the court assessed for the concealment came to less than $40,000. Sarah got half of that. She also kept the furniture and the car she had paid for herself. Derek left the apartment in late April. He was gone before the 1st of May. He couldn't stay in Denver professionally. The court's findings had been a matter of public record since March, and the construction industry in this city is not large. Two firms reached out to him in April, according to Linda, who heard it from someone in procurement. Both conversations ended when his background check came back. The judgment didn't carry a criminal finding, but it documented misrepresentation in a professional capacity. And that was enough. By summer, he was living with his mother in Tucson. I knew this because Sarah told me, not because I had asked. The desk was where I had left it. That was the thing that caught me off guard. 6 months after the judgment, when James walked me up to the 4th floor and opened the door to the corner office. The desk was the same one, the wide oak one with the drawer that stuck in humid weather, the one had moved up there in 2003 when we expanded. Someone had cleaned it. There was a new lamp on the left side. The chair was different. Everything else was the same. James set a cup of coffee on the desk and said, "Welcome back, Robert." The coffee was black. He had remembered that. I looked at it for a moment, then at the window. The city was below Colfax running east, the mountains to the west in the early morning light, the grid of streets I had spent 41 years building things on and under and around, the concrete supply yard on 6th, the Hennessy building, the new overpass on Alameda that my crew had consulted on in 2019, the last year before I retired. All of it still there. I didn't answer James right away. He didn't seem to need me to. He sat down in the chair across from the desk in the visitor's chair and opened his folder and waited. That was the thing about James Chen. He had never confused silence with absence. In 25 years of working together, he had learned that when I went quiet, it meant I was thinking, not withdrawing. He waited. Below on the street, I saw a man walking alone on the far side of the intersection. Shoulders forward, hands in his jacket pockets, moving without direction, the particular walk of someone with nowhere specific to be. The figure was too far away to identify with certainty, but the jacket was familiar, a gray one with a dark collar, and the build was right. He crossed the intersection and kept going east, and then the angle of the window cut him off. I picked up the coffee. It was the right temperature, not fresh, but not cold. Whoever had made it had timed it correctly. James said, "The Larimer Street project is still in proposal. We have a meeting Thursday with the city planning office. I'd like you there if you're ready." I said, "I'm ready." He nodded and made a note. Outside, the morning traffic was building on Colfax. A delivery truck double-parked in front of the coffee shop on the corner, and the driver got out and went inside, unhurried. The mountains were clear. In 41 years, I had watched the skyline of this city change from this window and from job sites and from the cabs of work trucks, and it had never looked exactly the same twice. The bones of it were the same. The bones of a city don't change easily. I had helped put some of those bones in place. I set the cup down and opened the folder James had left on the desk. The Larimer Street proposal. 42 pages, tabbed, with a site survey attached. I turned to the first page and began to read. The ink was fresh, and the margins were clean, and the numbers were right where they were supposed to be. James didn't say anything else. He didn't need to. Some things that have been true for a long time don't require announcement. They only require the right room, and enough time, and someone who stayed. If you've ever built something with your hands, a house, a career, a family, and then watched someone try to erase it in an afternoon, you already understand why a man like that doesn't raise his voice. He doesn't have to. The work speaks. The documents speak. 41 years of showing up speaks in a language that can't be shredded. If these stories find something true in you, I'll be here.